Viewers, welcome to the Personal Injury Law Show. This is a show that talks about everything current law of personal injuries and obviously of importance to you, the viewer. My name's Tony Carbone. I'm a personal injury lawyer with 30 years experience. With me tonight I've got a partner in a law firm in insurance law, Nunzio Tartaglia. Good evening, Nunzio.
Evening, Tony. Evening, viewers. Welcome.
And a senior lawyer in a law firm in insurance law and Comcare, Alexandra Agathouli. Good evening, Alexandra.
Good evening, Tony. Good evening, viewers.
Nunzio, we're in our 23rd series, 9th year. It's a long time.
Very long time, Tony. It's still going strong.
Yeah, we are.
Before we kick off, though, what's the news tonight?
There's been a lot of stories, as you all know. The one that's been probably the most alarming, or there's two really. The first story is about Dr. Parbar, who was running the Bacchus Marsh Obstetrics.
Yep.
And there's been at least 11 deaths, stillborn babies and other complications.
Yep.
From a perspective of an insurance lawyer, what do you say to all this?
Oh, this is a really sort of sad case, and also I think one that requires a lot more investigation, because we've got deaths of obviously stillborn babies and young people who, most importantly, could have been avoided, and that's the big issue in this case. And my issue with this particular doctor is that he's blaming everybody else except himself and the unit which he was in charge of, and that really concerns me, because he's blaming things like GPs referring him to the hospital, not having enough resources. I appreciate that's something that does play into it, Tony, but ultimately they've got to look after those they're looking after, and they didn't do so properly.
Exactly.
So.
And Alexandra, you'd think that someone with this sort of experience, right, would have know-how and you'd feel comfortable being treated by him, wouldn't you?
Well, of course. Like when a woman's pregnant and they put their lives and their lives of their unborn child in that doctor, and they trust that doctor. And I guess having this come out now, knowing that this had happened and that there were 11,
at least 11 stillborn.
Yeah, that we know about. It's unfortunate, and it's horrible
it's outrageous
to think that you can't trust your doctor.
What concerns me though is we're not talking one or two isolated deaths. We're talking 11. I don't understand why, and the answers haven't come forward. What's taking so long for Bacchus Marsh Hospital, the administration, the board, whoever you want to call it, to say, well, enough's enough, what's happening here?
Oh, obviously there's been a lot of cover-ups, Nunz. People worried about their jobs.
I think once this unfolds, I think there's going to be some pretty damaging findings.
I would have thought that there should be criminal charges on top of anything else, but people that have been affected should consult lawyers that are specialised in this area, because there will be claims here.
Look, most out, Tony, said you've got claims for the parents for post-traumatic stress disorder, because you're losing your stillborn or your kid. It's something that you just can't get over, and you may have a long-term consequence for that.
And for a fellow of this sort of experience, it's really astounding that he had a protocol that said that anyone under 34 weeks could transfer to another hospital. 34 weeks and above, he wouldn't. I mean, I find that absurd. Yeah. If they don't have the capabilities, they should just refer people on.
And for it to go for so long, that's the crazy part. So more to come on that one, I think.
Nunz, there's been a lot of people affected by this contaminated lettuce.
Yeah.
Not the least of my wife, who then passed it on to everyone else in the family.
So it's really sprung home for you. But look, Tony, this has been a big story just in the last sort of 4 or 5 days, where I think almost now there's 70 cases of people affected by salmonella as a result of these lettuce that was in both Coles and Woolworths.
I think it's the tip of the iceberg, pardon the pun, because they're the ones that have reported it. But imagine all the ones that have had, upset stomachs and vomiting and diarrhoea, Alexandra, and they've probably had this 24-hour scenario and they've decided to let it go.
Oh, that's right.
There'd be plenty of those, wouldn't there?
Oh, definitely, most certainly.
And in this area here, Nunz, what's their claim worth? What's it for?
Well, look, it all depends on the long-term consequences, Tony. Look, you've got, your medical expenses and those kind of things that we should be taken care of. But, like the Sheridan case, or, with the high tea poisoning, if there's long-term damage, then arguably you may have a permanent injury that's worth a lot more money. It
wouldn't be easy to show there's long-term damage unless there's some sort of damage to your bowels or...
That's right.
Or one of your
look, at the moment,
organs.
The cases have been, I think, isolated. There haven't been any sort of long-term serious damage. Let's hope that's not the case, but it is the case, but we'll see how we go.
Although many, many years ago, Alexandra, when there was the outbreak of the salmonella poisoning with the pizza, the Tabaldi salami, I'm talking many years ago, there was deaths that arose out of that. People actually died. So it can be pretty serious. So if you've got symptoms out there, you should really be consulting your doctors and getting some sort of treatment.
Do you think there'd be a class action?
But what's it worth? There's not a lot of mileage to it, Nunz.
It has to be thousands of people, wouldn't it?
Yeah,
And even then, it
I
still
mean,
might not
what do
be
you claim? You claim loss of earnings and medical treatment, which is probably picked up by Medicare and things like that.
And
There's not a lot of
and because they're
mileage.
self-insured, they'll probably take care of it anyway.
Yeah, I would have thought so. Ex-principal jailed and for assaulting 2 girls. They've got claims now, haven't they, Nunz?
Yeah, look, they do. Look, no doubt they got claims because he's been jailed and found guilty of those offences. I suppose the $64 question, Tony, is will they be able to get any money from this teacher or his principal? Because
Well, I would
what
have
asset
thought
base will he have?
you'd sue the school.
You think so?
Yeah, you'd think that.
What knowledge do they have, though? That's going to be the question.
I'd have a crack at both. You just don't know. I mean, he had a propensity, obviously, and they'd have to provide some sort of records or. You'd be surprised.
Look, if they're on notice about it, then arguably that there could be. What do you think, Alexandra?
Well, I thought, I guess when teachers obtain jobs at schools, they obviously have some sort of check. I would assume some sort of criminal history check or anything like that. So maybe that should be monitored more by schools, and that's something that could have been avoided.
I'd also speak to other teachers at the school to find out what his propensities were and if he showed any propensity to behave like this.
Yep.
And that would help because, I mean, if it raises the alarm bells, maybe they should have looked into it, don't you think?
Look, I agree. Look, and as I said, I think the easier way to get any compensation on this would be through the school because they're insured, and I think that's the avenue you'd want to go in this case anyway.
And not only that, I think perhaps maybe if there was an avenue for the children to have been able to speak up, like something to someone, a group of some sort or some other sort of, ability to be able to, speak to someone and tell them, this is what was happening. I guess they were young children. But
When they're 6 and 8 years
past.
old, it's very rare they'll listen to them. That's the other problem.
But usually you get the oldest truth from the most youngest kids.
Yeah, you do, because they just mimic everything, don't they? But the thing is, at 6 and 8 years of age, I wouldn't really listen to them, would I?
It's difficult.
Yeah. Well, just on that, whilst we're on the issue of sex pests and predators, what about this former teacher who groomed a Year 8 student for 5 years and was sending increasingly sexual messages to his young charge between 2000 and 2005? After 2 formal warnings and therapy, he wants a permit to teach again?
Yeah, look, I've got issues with this one, more because when you go into the facts of the case, when they were notified of his behaviour and what he was doing, he was told effectively, look, stop it, this is sort of your one chance, your one warning, and he still re-offended. So, to be frank, if I was the VCAT deputy member, I wouldn't give this any consideration at all.
Alexandra, you'd need some pretty serious counselling and treatment before you gave him another licence to teach again, wouldn't you?
Well, most certainly. Like this, he's committed, I guess, some sort of serious crime, and it's affected in this way. And again, it's you put your trust in these teachers, and that's just been.
Yeah, it's just outrageous.
That's correct.
And just lastly, before we go to a break, what about the water that was in the tunnels? I mean, assuming something drastic happened and they collapsed, who knows?
Oh, look, if there's water in the City Loop tunnel, which is just around the corner from our work, so it's pretty dangerous situation. If there is a flood there, that would just be horrific, and the consequences are massive. So let's hope that that's just an isolated event that they've fixed up.
Let's hope, because it would be a class action for sure. Yeah.
And deaths, unfortunately.
Viewers, we've got to go to a sponsors break. Stay tuned. After the break, we're going to give you a Comcare update, which is an absolute must. Viewers, welcome back to the show. Tonight, viewers, we're going to be talking about the Commonwealth Employees Compensation Scheme. It sounds big and beautiful and full of benefits, but it's not. Alexandra, on that note, give us a summary of the main differences with the Comcare system.
So basically, the Comcare system is governed by the Safety Rehabilitation Act, or the SRC Act, and that basically means the employees that are employed by employers who are under the Commonwealth scheme or who have been given a licence under the Comcare scheme. Generally, these employers include TNT, Telstra, Australia Post, KNS Freighters, things like that, where they're the ones who also their business runs nationally. That's the reason why they're able to be under the Comcare scheme. So basically, it's a no-fault system, so the employees have a right to compensation in the sense that they get their weekly payments and their medical expenses paid for, and they don't have to prove fault against their employer. So basically, if their employer was at fault for something, they don't actually have to prove that. That's the benefit of it. The downside is that in order to get a common law settlement, so to claim for pain and suffering damages, you actually need to satisfy the test of a greater than 10% whole person impairment, and that's governed by the Comcare guides. And to get that, you need to have a pretty severe injury, and therefore, if you do satisfy the test and get greater than 10%, then you can sue your employer for common law damages, but you elect to give up the compensation that falls under the impairment claim, and then sue for pain and suffering damages, which is also capped at $110,000.
Can I just stop you there, Alexandra? The important thing here, Nunzio, is this. This piece of legislation was amended on the 1st of December 1988.
Yep.
Right? The maximum amount, viewers, you could get for lump sum for common law damages back then was $110,000. And in the year 2016, guess what the maximum amount is, Nunzio?
Still 110.
$110,000. Never been indexed. It's been the same amount of money. $110,000 in 1988 would probably get you half a house.
Well, we'll compare it. What's work cover, Tony?
Work cover? Well, it's gone up to $550,000+.
TAC?
TAC is about the same.
And public liability med neg?
Is about 400 plus.
Yeah. So,
and it gets better. You've got to make an election very early in the piece. So if you're on benefits, weekly payments, right, and you want to go common law, you make an election. So once you've elected, that's if you get the 10% Alexandra was trying to explain. Then if the common law goes sour, you can't go back on the benefits.
That's right. Look, the reality is they're basically saying don't sue us because it's not worth it and you're not going to get much money. And, Alex said that, the benefit is it's a no-fault system, but so is work cover. But you still
of course it is.
Work cover, you get the no-fault entitlement and also you get the common law entitlement. So I don't see it as a benefit, I just see it as a severe it's a
diminution or reduction in workers' benefits.
That's right.
You agree?
Totally agree.
And Alexandra, over the years, it's a proven fact, especially when we had the changes to the workers' compensation system in Victoria under Kennett's regime, that once the system of fault goes out the door, employers are a bit haphazard about the way they look after their employees because there's no penalties if they muck up. Do you know what I mean?
No, that's correct. That's correct.
So anyway, let's keep going. So the government's effectively changed the legislation and made it easier for employers to kick into the Comcare system. Is that correct?
That's correct. Originally, back in 2007, it was abolished where the employers who had their businesses nationwide, they were unable to go under the Comcare scheme or given a licence under the Comcare scheme. However, just last year with the new government, they're now given the opportunity to be able to be licensed under the Comcare scheme and therefore avoid having licences in each state, and therefore they can just go under the one scheme.
Well, Nunzio, in Victoria in particular, which is the system we operate under, it'd be a real serious reduction in the workers' benefits, wouldn't it?
Oh, look, massively, Tony. And they said, look, depending which avenue you're looking at it, like if you're an employer and you could get a Comcare licence, to be frank, it's a no-brainer. You're going to be paying less premiums, you're paying out less compensation, and you probably have less claims.
Oh, for sure.
Look, I can understand with these new proposed changes that are in place. I'm not surprised by why the Chamber of Commerce is voting for it, because employers are going to save millions and millions of dollars, but that's not the motivation of the system. It should be to protect workers, and that's why I think a lot of us who appear for plaintiffs are upset by these systems.
Well, the common law system's been around for years and years and years. Well, it started back in 1932 with Donoghue and Stevenson, right? And you'd think that, why would you want to erode rights that go so far back?
Look, it's going to, unfortunately though, it's a bit of a moving beast, because at the moment there's about 30 large companies are under the Comcare system, and now that they've opened it up, as Alexandra said, my fear is just that this could just blow out.
Oh, guaranteed. Guaranteed.
There's
a lot of companies that trade in Victoria and other jurisdictions. If they apply, I don't know how you can stop them. It really becomes a massive, massive problem. And sadly for the viewers, I mean, this is an opportunity, I guess, for you guys to speak up, maybe write to your members of parliament or whatever else, and just air your views, because if they do change it, it's going to be to your detriment, because the system is lousy.
Especially with those companies that have more blue collar workers. If they become nationalised in terms of under the Comcare system, they're the ones with more claims because they've got physical labour, physical activity.
Of course.
We could have some pretty serious injuries without getting compensation.
Exactly. And it means that the worker will have to pick up more premiums buying other policies of insurance.
Income protection.
Yeah. So it's just shifting the burden from the employer to the worker.
Exactly right.
Anyway, let's get on to a couple of case studies. There's been a lot of injuries in detention centres under the Comcare regime, Alexandra. Now, if you go through the history of it, Nunz, there's been 449 incidents affecting staff and detainees in all these detention centres, and Greg Barnes, the ALA spokesperson, has taken up the charge because he's really upset about what's going on. Tell us a bit about the background to this.
Because we've had Greg on the show, and so he's a proponent and he's an advocate for these type of issues. And I think this goes to the fact that, like you said before, because it's a bit of a no-fault system, they're not doing enough about workplace change and safety. And this is an example of that, because you've got over, just under 500 detainees and staff being injured, assaulted and the like, and they're not doing anything about it, Tony.
Well, there's only been a couple of reports.
That's right, and that's part of Comcare's system. Comcare's responsibilities. They've got to oversee it, investigate it, and make sure change occurs. And they're not doing that because there's no motivation to do it. And that's our concern.
Have a look at some of these examples here. Alexandra, give us some of the examples of incidents that have occurred in the detention centres.
Well, it's one would be witnessing a suicide, for example. Witnessing a drowning. There was an incident where there was a witnessing of a drowning, and therefore they developed psychological injury as a result of that.
Yep.
And they're also diagnosed with obviously post-traumatic stress disorder. They saw some serious injuries in incidents where contractors' legs were crushed. Also contracting tuberculosis and the effects of that.
What, in this day and age, tuberculosis? Unbelievable.
Yeah.
A worker suspected of contracting Japanese encephalitis in Papua New Guinea. I mean, these are just some serious examples of what's gone down in these detention centres, and nothing's occurred.
For a long period of time.
And undetected.
Exactly. We're going to go to a sponsors break. Viewers, please stay tuned. After the break, we'll take up this issue further, and it's obviously of interest to you, and we'll also give you some case studies. Viewers, welcome back to the show. Before the break, we're talking about all the incidents that occur on Manus Island and all these other detention centres, Villawood, etc., etc.
On that, Tony, though, we just got a call over during the break. You're talking about encephalitis. Explain that to the viewers a bit more.
Pronounced encephalitis or encephalitis. It's a condition that affects your brain. It's a virus that goes into your bloodstream. It's a strain of the herpes virus, and it attacks your brain. In severe cases, obviously you die or you become a vegetable, and in less severe cases, it affects your memory. So they're very, very serious. Mind you, I had a case like this many years ago, which I settled for 1.2 million knots. And the thing is, that fellow was so badly affected he couldn't go back to work. And Alexandra, if the hospital in that case had done the right thing and done a lumbar puncture, they would have found that he had this virus. They could have given him medication and it would have treated it and prevented the symptoms that he subsequently suffered from, which was short-term memory loss. Anyway, on that note, we'll keep moving. So the detention centres is obviously a major issue, and Greg Barnes, keep up the fight because you do a great job. Now, there's a case that, I can't pronounce it, but I think it's Zaraski and Telstra Corporation Limited. It's a 2015 full Court of Appeal decision. Alexandra, can you give us the facts?
So we'll just call him Mr. Z for the purposes
Yes.
of today. So he was a former employee of Telstra. He commenced working in 1973 as a technician. He was injured at work whilst he was working on a table and he was leaning on it and he collapsed and the legs of the table gave way. As a result of this, Mr. Z fell backwards, fell onto his left side, and he sustained an injury to his shoulder, ruptured a disc in his spine and suffered injuries to both his knees. Obviously, Mr. Z had some significant treatment. He did lodge a workers' compensation claim under the Comcare scheme, which was accepted for his physical condition. However, as a result of all the medication that he was taking, he did develop a psychiatric condition as well, and then subsequently lodged a second claim, and that was for depression, emotional stress and physical stress. Telstra unfortunately rejected that claim, and therefore he made an application to the tribunal after the second review.
Okay. Nunz, importantly, this fellow had really severe physical injuries.
Yep.
Okay? Multiple surgeries, etc., etc.,
Yep.
etc.
Yep.
The reality is he probably wouldn't go back to work. However, due to all the medication he took and he was prescribed, he developed a severe psychiatric condition.
Yep.
The employer challenged it for what reason?
Well, because before the incident he had a drinking problem or a substance problem, and effectively they were saying he's just replaced that drinking problem with medication. Again, we talk about Comcare being a no-fault system, and this unfortunate plaintiff is sort of done for life because of physical injuries, and the fact that they can't accept the psychological sort of consequence of that is really concerning. And he had to go all the way to the federal court, in which they've now just reverted it back to the AAT again. So, the cost will outweigh the benefit for this poor gentleman.
Of course. Alexandra, the key to it is this. If you get a determination that's unfavourable, you only got 30 days to appeal it. Is that correct?
That's correct, 30 days.
So you've really got to act pretty quickly.
Is that strict, Alexandra?
It is a strict 30 days. However, if you're unrepresented and you haven't gone to any lawyers, you can either ask for an extension to give you time to seek legal advice, or if you have run out of time and you have sought legal advice, then the lawyers will obviously, write to whether it's Comcare or the self-insurer to humbly request for an extension of time in order to do that. But some employers do take the point, and it is a strict 30 days.
Well, this matter ended up in the full Court of Appeal on the issue whether they should accept the psychiatric injuries nods. And this is why the viewers should consult an experienced law firm in Comcare, because the system's so convoluted.
There is, and there was different tests, there's different ways of proving what's an injury, what's a disease, and it's really actually a convoluted act. It's not straightforward, and with respect to the lay person, you need legal advice to sort of sort through all that, because
well, in Carbone, we've got people that can do that.
Look, we do, and look, Alexandra does specialise in Comcare, and we've made a name in helping our clients in the Comcare system, and that's why you have to seek legal advice.
Alexandra, over the years, there's been some significant changes in the wording of the legislation as to whether to accept an injury, and what we knew as an injury being materially caused by work has now changed to a significant degree caused by work, which means it's a degree that is substantially more than material.
That's correct.
It's really, really complicated, isn't it?
It is quite complicated, and that's one of the things that also our clients find difficult to understand, and also the viewers who are have Comcare claims on foot now, and it's something that they might not get, not understand.
They wouldn't be able to understand it.
And differentiate between the two.
And on that point, that's why when you first have to review a decision, and you've got 30 days to do so, it's not as simple as penning a letter to the self-insurer or Comcare, because you've got tests and you've got legislation. If you get this wrong, that's evidence already been used. So that's why you have to seek legal advice first, because then we can set that up for you.
Exactly. Well, look, in this case, as it turns out, because his injury manifested itself before 2007, that is April 2007,
yep.
Whether it was material degree or significant degree was irrelevant.
Yeah, exactly right.
And to their credit, the full court found in the plaintiff's favour.
They did, but they reverted back to the AAT to be heard before another member. So,
which means essentially that the applicant should succeed.
We hope so.
I'm confident they will. What do you think, Alexandra?
I hope so too.
Yeah. Okay. Let's quickly go through the facts of CASA and Australia Postal Corporation. Can you give us the facts of this, please?
Okay,
Alexandra?
so Deborah Casa worked for Australia Post on a part-time basis. She was a postie. She was then, in January 2012, she reported to her supervisor that she sustained an injury to her right shoulder, and that she indicated that this was due to sorting mail. She lodged a claim under the workers' compensation claim under their Comcare scheme, and she was getting some treatment for that. It was initially accepted. Her claim was initially accepted. However, through the medical treatment that she was having, one of her orthopaedic surgeons had suggested that she needs surgery and made a request to the insurer to have that surgery, and unfortunately the insurer denied payment of that surgery and also stopped paying for all of her medical treatment and her weekly payments as a result of that.
Okay. Nunz, one of the key elements in this case was that when the claim form was filled out, it was filled out by a fellow worker,
Yep.
right? Partly because this worker didn't understand proper English. And one of the things she did not put in her claim form was that she had 2 prior instances of shoulder injuries at work, which she did not claim because they weren't serious.
Yeah, look, she failed to disclose 2 previous incidents in 2003 and 2009, which, look, they wouldn't have changed the outcome of the case, but
No.
unfortunately just affected her credibility. It's like, have you got something to hide? And what, injured people or plaintiffs need to realise that putting all the information out there is not bad, because it actually goes to the fact
helps.
that you continue working and you're fine. So it was a roadblock, but ultimately she succeeded.
Well, the court saw through it, thank Christ.
And I think they should, because she had so many treating orthopaedic surgeons supporting her, saying that this tear was related to work. And ultimately she was successful, and Mark Carey, who we use a lot as our counsel, assisted her greatly.
Exactly.
So-
Alexandra, it would have been a travesty of justice should this lady have failed because she failed to disclose 2 previous incidents where she didn't deem them serious enough to make a complaint, and yet all she had to do is put them in the claim form and it would have been no issue, correct?
Yes, that is correct, because there is a section of the Act, unfortunately, that and a lot of respondents do take the point where if you do fail to disclose any pre-existing conditions, you are precluded from receiving any compensation under the Act.
Unfortunately, viewers, we come to the end of the show. Alessandra, thanks for coming on board. Nunz,
Thank you.
always a pleasure.
Tony, thank you.
Viewers, go to our social media platforms to catch up on our past episodes. Stay tuned for future episodes, but please always remember to stay safe.